Good morning. Happy Wednesday. Happy hump day. We're almost, I guess when today's halfway over, we'll be halfway through the work week. So I read through Meyer's reply brief. He filed a motion to modify the terms of his probation. The state opposed it, and he filed a reply brief. And it was shockingly bad. Shockingly bad. The first argument he made is that he couldn't be asking for this to harass the victim because he had reached out to the state's council to see if she'd be willing to negotiate different terms. That doesn't follow. That is a non sequitur. Just because you asked opposing counsel to modify the terms like by stipulation doesn't mean that you're still not trying to get those terms modified so that you can harass the victim. And I don't see how he needs those terms modified other than to harass the victim. I know he thinks he's covering news stories and things like that, but he doesn't seem to have the ability to do things without stepping into the realm of harassment. Like, for example, with the Joe ad stream that he did, that just, from what I could see, involved playing music and showing penises pointed at various people's faces. Like, that's not hard-hitting news commentary, you know what I'm saying? Like, that's just insulting people for the sake of insulting them. So I don't see any reason for him to ask for it other than to harass the victim. I'll be honest with you. The second thing that really stuck out to me was he said, here's the case that the trial court relied on in setting the terms of probation. And that was State versus Kessler, I believe. And then he said that the state raised two other cases in their brief that were inapposite. They didn't apply because the underlying facts of those cases didn't deal with similar facts to this case. And then then it stopped. That was his analysis. That was it. He didn't identify the cases that they raised or explain why the facts were inapposite or how the holdings that the state extracted from them, the citations, were dicta or otherwise inapposite, inapplicable to this particular situation. He just said, the facts are different, doesn't apply, doesn't work. But let's just even grant him that they had different facts. Like, how does that change anything? Because you still got Kessler, which he agreed was controlling case law. And Kessler dealt with removing someone's First Amendment protections for certain activities. Kessler, if I remember correctly, was... and another argument is that he made was directly refuted by Kessler because, he said that the things that he was essentially, I think his argument was, because it was very disjointed, was that he only pled guilty to 2 counts and none of those things relate to the people that he's not allowed to have communication with. But in Kessler, the one case he agrees is on point, the defendant was charged with, I believe, sexually assaulting a minor or attempted sexual assault of a minor. I haven't read the case since I first reviewed it way back in the day, so double check me, but I'm pretty sure that it was like sexual assault of a minor or something bad sexually related. Now, he pled guilty to, I think, like felony assault, like not sexual assault, but the charge that he pled guilty to was like a low-level felony assault, like a felony 6, which is like the bottom of the felony chain. So it was a very minor thing that he actually pled to, as opposed to what he was charged with. Probation recommended no contact with kids. and they spelled out how he was supposed to have no contact with kids. Very specific. You can't talk to them or anything like that. If you're going to be somewhere where there's going to be kids, you have to have like a specific chaperone, blah, blah, blah. I mean, very detailed instructions on no contact with kids. Now, that is a First Amendment infringement. So the First Amendment was clearly implicated. And it didn't relate to what he actually pled guilty to. So Kessler doesn't help on that. But Kessler said, I guess he went to some like church camp or something like that, and he lied to his probation officer about it, and he ended up like sleeping in a tent with a father and the father's 13-year-old child, and had other various unsupervised interactions with children at this camp. No allegations he actually did anything inappropriate other than violating the terms of his probation. So, I'm not saying this guy did anything like super bad. It was just the fact that he violated the terms of his probation, which had no contact requirements about children. And there was no chaperone there, I guess, to make sure that nothing bad happened. So, I mean, he just completely violated. And he's like, no, this is overbroad. And the court said, no, it's not overbroad because what you're doing was within the clearly defined scope of what you're not supposed to be doing. So overbreadth doesn't matter. I also think overbreadth is not a good argument for Myers, who, if he had read Kessler, would understand that. And as long as what the court orders as terms of probation are related to either helping prevent future crime, similar to what you were accused of, not necessarily what you pled to, because remember, in Kessler, he only pled to assault, but the charges that he bargained away were about sexually assaulting a minor. And so the restrictions in Kessler were directly related to preventing that kind of crime from happening again and rehabilitating Kessler. Myers' restrictions are directly related to preventing Myers from reoffending and rehabilitating Myers. Like, Kessler's so on point that you really don't need another case. So how them citing a couple other cases that Myers thinks are an apposite, but never lays out an argument as to exactly why. Oh, the facts are different. Okay, and every case has different facts. Are the facts close enough? Is the court addressing essentially the same issue? Like in State versus Smith. The guy was on probation. You give up a lot of rights to go out on probation. Like, the cops can search you at any time. You can't say no to a search. Now, if you weren't on probation, the cops would have to have at least probable cause to do a Terry frisk, that you're armed and there's crime afoot, or they have to have probable cause to search you. So they need to meet certain constitutional requirements. But if you're out on probation and the terms of your probation have waived the right to be free from unreasonable searches and seizures, they could stop you and search you at any time. And if you say no, probably you're violating your probation. So you give up a lot of rights. And in State versus Smith, the state got a probation violation based on unmirandized admissions from the defendant. And the state's argument in State versus Smith was that, no, he gave up those rights. He gave up those rights. No Miranda rights for you if you're on probation. So we're talking about a probation, so that's the same. We're talking about giving up some rights, that's the same. And the question in front of the court was, do you give up Miranda rights? And the court said, you give up all sorts of rights. You don't give up Miranda rights, but you give up all sorts of rights. So it is somewhat on point. The state can make an argument. And the part of State versus Smith that the state quotes, one of the things that Lane Myers could, would, and should have done if he was actually good at the law, which he's not. I still don't understand how his supporters think he's good at the law, is he should have looked to see how is that particular section quoted in other cases. Is it quoted in a wide variety of probation violation cases or cases challenging the terms and conditions of probation? Is it raised? But he didn't do any of the analysis. He didn't do any of the work. He just shit out 6 pages of nonsense. Like that reply brief is not going to help the court at all. It's not going to give the court what the court needs to see how the state's argument is deficient. If, in fact, the state's argument is deficient. We don't know because Lane Myers didn't do the work. He just stream of consciousness, shit out 6 pages of nonsense, and then he's going to blame the court for being biased against him because he didn't do what he was supposed to do. This is why you have an attorney, Myers, or you had an attorney. You should have had your attorney do this work for you. You would have a better chance. Assuming you haven't done any probation violations that probation is aware of and that they're going to include in their probation report, you have had a much better chance of having the terms and conditions of your probation modified. I know you don't like lawyers, even though you pretend you are one. So fucking weird. Lawyers suck. Brr, 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 brr. I am a lawyer. I am a lawyer representing myself. So for the terms of this case, I'm a lawyer. No, you're not, dude. No, you're not. You have a lawyer, or the court assigned you a lawyer, a public defender. You should have seen if he would have done this for you. He might have. I don't know. I've never been a public defender, and I've never been a public defender specifically in Arizona, so I don't know. But he might have. You should have asked him, or maybe hired an attorney with all the money that you apparently have because you could spend all day streaming. So it's the reply brief does nothing to help him. I don't know what evidence probation has, what they're going to bring forward, but just looking at the evidence that the state had in their brief, it doesn't look good for a positive modification for Myers. The court may just on its own modify the conditions to be worse, to be harsher for Myers. I don't know. I am not optimistic about Myers' chances. Now, there's always a chance. Courts make mistakes all the time. Speaking of which, I don't think, based on the comments that I saw in my comment section, I don't think people quite understood what I was saying. I was explaining what the judge said, but I did not agree with it because, again, who was defamed? The YouTuber. Who's the YouTuber? And the court's logic also didn't make sense in Long Island Audit's statement of decision, because the assumption was that you have this corporation to protect you from lawsuits. The corporation is the one who would get sued, and the corporate veil would cover the shareholders. Now, yeah, you can sometimes pierce the corporate veil, but that is the exception to the rule. And if you're focused on exceptions to the rule all the time, you'll never understand the fucking rule. So the rule is, the reason why people make corporations is to protect the shareholders. It decreases the potential liability of shareholders. Partnerships, the partners are all on the hook for everything. A corporation, the shareholders may or may not be, but the general rule is they're not. The corporation is the one that's liable. There are circumstances under which you could pierce the corporate veil. That's why they have a term for it, piercing the corporate veil, where you can get at the actual shareholders for liability. But the general rule, the whole purpose of a corporation, the reason why corporations exist, is to protect the shareholders, or else all we'd have are partnerships. So, the court's analogy of that is really weird, and I didn't understand it. I didn't understand how the court got there. Because if Long Island Audits, if Sean Paul Reyes got up on the Long Island Audits YouTube channel and said, Mayor, what is his name? Alfrey, whatever. And if he said that mayor is a PDF file, that would be defamation, right? That'd be defamation. Now, who could the mayor sue? Well, the mayor could sue Long Island Audits because Long Island Audits published it. And the mayor could also sue Sean Paul Reyes because Sean Paul Reyes said it. And how do I know this? Because you've seen it happen before. Rachel Maddow's been sued a number of times for defamation. They also sue MSNBC. Why do they sue Maddow? Because she's the one who said it. She's responsible for what she says. Why do they sue MSNBC? Because they published it. Technically, she also published it because, she published it, but then they republished it by broadcasting it. So the corporate analogy thing doesn't work. I don't understand how the court got there, but trying to use the court's logic is what I would do, because I know he's filed a motion for reconsideration. I haven't actually looked at his motion for reconsideration yet. Maybe I'll do it tonight if I have time. But when you're asking the court to reconsider, you want to use the court's logic to reconsider, because that's the way that judge is thinking. And I have never found it to be particularly successful to say, Judge, you're dumb and wrong, and here's how you should think. So I try to make my arguments line up with the judge's logic train so that the judge can be like, oh, okay. I understand that logic train because it's my logic train, and I can see where you're getting. On the other hand, if you're planning on appealing, well, then you want to do the judges, and then also you want to do like what you believe the actual law is. But the judge's logic didn't make sense to me. Because again, if you flip those shoes, who would be liable? It would be Sean Paul Reyes and Long Island Audits. So why can't, if you flip it around, why can't Sean Paul Reyes sue if you said, the YouTuber, which would, even if we don't get to who the mayor meant when he said the YouTuber, I would still argue that no, like, I am the face of that. I'm the YouTuber. People assume it's talking about me. I assume it's talking about me. So the defamation is about me. But anyway. So judges make mistakes all the time. That's why you can never be sure. That's why I never give 100% guarantees on anything. I say this is the likelihood. There's a likely way. Anyway, I've rambled long enough. I didn't intend to make an 18-minute video. I have a lot of work to do today. Thanks for watching and have a great day.